Pink and white. This pink and white summon has been served, sir, to the FSL expert.
Should we wait?
Yes, sir, we'll wait. Because it has been served through SP. It has been forwarded to the SP of Kamrup, Assam.
Well, then how will he appear?
So we didn't have his number also to contact him. Sir.
Only one. But not sir. It's just been sent to Kamrup.
Yes.
Where is the evidence that it has been served?
Yes, it's written after causing service.
Which was received in service with a request to kindly return the issue. But not sir. It was shown so present. Accused pink and dye produced from jail is after BC. Defense counsel present. It appears that summon issued to the witness was forwarded to the Superintendent of Police Kamrup for effective service. Summon has not been returned. Prosecution is at liberty to take fresh step. And needless to say that the witness, who is a forensic expert, station at Kamrup, Assam, may appear through VC. The prosecution shall provide the VC link in the summon. Accused remanded back for 14 days judicial custody.
Cut back, so. There's no witness to this. No witness to this.
It appears that prosecution has not taken steps to summon the witnesses. Prosecution shall take steps to summon the witnesses. Yes. Accused remanded.
Jimmy, good night.
In this case also, there's no witness today.
But why no steps taken? Why the prosecution has not taken steps?
So because I had already made a prayer earlier, so that in these cases are UTP 14 days, someone could not be served to the witness. So if they appeared on the last date, if witness appeared, then on the next day will be fixed for production.
Unique indictment produced from Jaintia ABC. Defense counsel J.C. Tarian present. Prosecutor Srimati So present. It appears that prosecution has not taken steps to summon the witness. Prosecution shall take steps to summon the witness. Refix for evidence. Now again it will come after 14 days. How do you manage it?
I'll find out the address first of the witness where we are nearer. So we'll summon those witnesses.
Yes. Yes.
This Loris, she has received a summons and she hasn't turned up yet. Sir. Summon has been received by the witness.
Accused Loris Dakhar produced from Jailazad. Defense counsel M. Nazir present. Prosecutor Srimati S. Kindia present. Summon issued to the witness returned, duly served. The witness is absent without any steps. Where is this? Mupur village?
But it's not far, sir. Amaran side. We'll wait, sir.
If the witness fails to appear during the course of the day, the prosecution is at liberty to take coercive steps to secure the presence of the witness.
Fixed for attention. Court was on leave and on the last date.
No witness, Your Honor.
Yes, present.
Accused President Dakhar present, along with defense counsel T. Lampa. Prosecutor S. Chansang present. Prosecution shall take steps to summon the witnesses. Yes.
We step down, Madam. The argument has been concluded, Jana, for both sides.
What is the case?
302.
How many witnesses?
Then,
Can you just refresh me?
yes, Jana.
Can you refresh?
Yes, yes. This is a case where the accused has allegedly killed the deceased in the compound of PW1, Jana. Where I just read to refresh. Say that on the day of the incident, I was at home. The incident occurred at 8 a.m. in the morning. At the relevant time, I was busy with my household chores and cooking vegetables. The deceased late Rajai Kandai was passing by my house and sat down in the compound of my house. Suddenly, I heard the accused telling the deceased that he is tired of the deceased, calling him again and again. On hearing the noise of the accused person, I came out of the house and I saw the deceased was lying dead with a cut injury on his neck. Thereafter, I became unconscious. I did not inquire about the incident from the accused. This is a case where he also made a extrajudicial confessional to me. PW who is the member of the Promotional. This case.
What is your defense?
My defense rely that this PW first for PW1. For PW1, although she stated he heard the accused, my argument is that she never stated that she saw with her own eyes that the accused hit the deceased. Moreover, she never stated that when she went outside, she saw the accused there or running. So she never stated that. She just stated that when she went outside, she saw us. She saw the deceased lying dead, and she became unconscious. That's
What's the difference between heard and saw?
She stated that she heard the accused there coming to the near the compound of her house.
How do you hear a person coming?
She heard the noise, like his voice. That's what she stated. She heard. Suddenly, she heard the accused telling the deceased that he's tired of him. That's what she stated. Moreover, when she went outside, she was silent whether the accused was there or not. But the accused he ran away from that PO towards his house or toward anywhere. Never stated about that. She just saw that a body lying on the ground and she became unconscious. And for the
No. Criminal trial is a mathematics. Is it a mathematics that it has to be with precision?
no,
That it has to be established with precision. There is some formula. The facts has to come on those formulas, and then only we get the answer.
She stated the incident happened right in her compound.
With evidence of PW1. Who is PW1?
She's just the villager, the
Right.
same villager of the deceased.
What she says?
She said that on the day of the incident, I was at home. The incident occurred at 8 a.m. in the morning. At that relevant time, I was busy with my household chores and cooking vegetables. The deceased late Jaintia was passing by my house and sat down in the compound of my house. Suddenly, I heard the accused person telling the deceased that he is tired of the deceased person calling him again and again. On hearing the noise of the accused person, I came out of the house and saw the deceased was lying dead with a cut injury on his neck. Thereafter, I became unconscious. I did not inquire about the incident from the accused person. The accused person was present in the dock today, in the cross. I know the accused person as we are in talking terms. It is a fact the voice that I heard of the accused person is of the accused person. It is a fact that I did not witness the occurrence, but I only saw when I came out of my house that the deceased was lying dead with a cut injury on his neck. I do not know whether there is any enmity between the accused person and the deceased.
Yes.
My argument is that she stated this incident occurred right in front of her compound. And when she heard the accused, she stated she heard the accused calling the deceased. She went outside. When she went outside, she saw the deceased lying dead. She never stated whether the accused was dead, whether, as alleged that by other PWs that he has a doubt, that also she never stated. Whether he ran away from that place, also she never stated that. Because it happened, as alleged by her, happened right in front of her compound, inside compound. She must have seen everything. But think whether the accused ran away after he committed crime.
So what is the other possible view?
Other person is that.
Then what is the other possible view of the evidence which emerges from the evidence of PW1?
The time period,
Yes.
She said she heard and she went outside. Whether that time period is enough to kill a person like that, whether enough time a person to run away. Because she said that right after she heard, she went outside. She saw a cut injury.
This is the only evidence?
No, one more. He made a original extrajudicial confess to PW8.
I know the accused. I know the accused who is from the same village. I know the deceased who is also from the same village. But the incident occurred on 2007. If you are appearing for the prosecution,
Oh, PP is still appearing in the PS courts.
what is the explanation to this?
The deceased is my brother-in-law. I am married to his younger sister. On the day of the incident, I went along with my wife in the morning to burn charcoal. That's his explanation. Said that he was not present. He was not present at that view.
Where he says, I was not present.
Deceased is my brother-in-law. I am married to his younger sister. On the day of the incident, I went along with my wife to burn charcoal. That is the matter.
Where does he say that? What? How does he explain? He says that he's not there.
He said he went along with his wife to burn charcoal.
So, any proof that you went to burn the charcoal? The plea of alibi?
No.
Then? And what is your explanation to the confession made to PW8?
So that it's not true that I made a confession before PW8 that I'm adultery or that.
You have 161 statement of the PW1.
No, I don't know. They're
I
saying
have,
161.
it's there in the CDs.
Can I have it? Can I have the statement of 161?
I'll just read it. So on examination, she stated that on the 13th to 2007, she was preparing food for the morning, and the husband was also
Give it, please.
coming out the handwriting. But on the coming out handwriting, so just making bed on the meadow just in front of their house. At about 7:30 a.m., Sri Laja's Kandai came and her husband chatted with Lajai for some time. When her husband entered into the house to look for a hammer, and at that moment the accused Sri Las Sungo appeared and found Laja's Kandai lying on with a deep cut mark on the back of the neck. Then the accused, leaving the dead body, and left saying that he is going to inform about the incident to the family of the victim.
What's the name of the accused?
Mr. Sumar.
What case is this? What kind of a trial is this? And what is your cross-examination? You did not have access to statement under 161.
No supply. No supply.
It's too late to ask for the statement under 161. How are you cross-examining the witness without having the previous statement of the witness? What is this case?
Because the 161 was written on the CD itself, there's no separate statement, so that's why maybe let's serve them copy.
Where is the charge sheet? How did you cross-examine the witness without having the statement under section 161 before you? Who is lost Suma? Please explain me. I'm not that came to the husband. 7 Sri Lajai Kandai is the deceased. Came and his or her husband Lajai Kandai came and her husband chatted with Lajai
Sometime.
for some time. When her husband entered the room to look for a hammer, at that moment the accused Sri Loss appeared and found. What is this? He's a witness.
It's not a witness.
Okay. We take this matter after evidence. But how? You did not have the copy of charge sheet.
Charge sheet is there, but no 161.
You did not ask for the statement of the witness under 161.
I have been close with my copies.
How did you cross-examine the witness?
Only based on the incident.
Before, most of the 161 statement were recorded in the CD itself, and if the defense asked for a copy, we used to Xerox and give them a copy.
It's not a question of defense asking for the copies. You look section 173.
Yes,
What are the documents which needs to be provided to the accused under section 207? All the incriminating materials which the prosecution intends to use during the course of trial against the accused should be supplied to the accused. If you have not supplied, then you can't use it. You stood for a trial, examine the witnesses without having the documents with you. Yes. But then look at the examination of the witness by the prosecution. I don't know whether it's a murder case or not, but certainly the prosecution has murdered the case. What is this recording of this statement? Totally different case before the court. The investigation is something, the trial is something, the argument is something. Who says that she heard? Who says that she heard the accused?
On hearing the noise of the accused in chief.
In a trial, you will prove the statement of the witness under section 161, isn't it?
Yes, sir.
Or will you make out a new case in the trial?
Yes.
What is the statement under 161 of the accused, of the witness?
Different, sir.
So you make out a new case in the court. A witness who has not seen anything during investigation becomes an eyewitness in the trial. We'll take it up after this. But I'm shocked that in a murder case, how can you face trial without having the copies of the statement of the witnesses under section 161?
At the very early stage, it was never supplied to us. So we were not informed that there was some.
Can you play a
statements
football match
162.
without football?
That's what I'm trying to imply.
Can you play a football match without football? Can you say that we did not get the football, that's why we are
We
playing
have the
football?
confessional statement. That is what we and
No,
whatever
you
was,
can't say
recorded
that I'm
was-
playing football without football.
Yes, and
There
so-
cannot be a match. How can there be a trial without a copy of the charge sheet?
And as
What is this trial all about?
mentioned that it was a part and parcel of the CD. It was never able for us to be given the copy of the CD.
No, it's all right. Whatever may be the case, the trial has to be in accordance with law.
Yes.
There cannot be any excuses that the entire trial falls only on this argument. The trial was conducted without supplying me the copy of charge sheet.
It was never enclosed also, Your Honor. What are the...
Fine, it was never enclosed. Did not the witness come to the court?
Yeah, they came. We examined them.
You cross-examine.
Yes.
How did you cross-examine a witness? It's a common sense. What happens in the trial?
Yes, Your Honor.
The prosecution will try to establish the statement under 161. Or will the prosecution conduct a trial like a Hindi film? Man standing on the road, they'll say, come to the court, stand as a witness. The matter was investigated. Somebody made a statement under section 164. Based on those statements, the prosecution had built up a case and filed a charge sheet. What is the basis of filing the charge sheet? The basis of filing the charge sheet is the evidence collected by the investigating officer. And what are those evidence? Evidence are in the form of a statement under section 161, incriminating material seized. Now those materials has to be given to the accused person. Why should we hear the matter? Why should we hear the matter on the merit of the matter? When the genesis of the trial is also, it's on the face of the record defective. This is not a fair trial. How can we hold a trial by withholding a valuable documents? How can there be a trial without supplying the copy of charge sheet? You have projected PW1 as a very vital witness. But after reading the statement of the witness under section 161, it appears that you have made out a new case before the court. Why was the charge sheet filed against the accused? What is the evidence of the IO? The IO in his testimony, he has stated
He expired, Your Honor, before he could testify.
very strange. We'll take up these two matters, Ram Phawa and these two matters after evidence. Yes.
Number 2 is undergoing treatment admin hands.
Okay, see this. Yes, yes. Will record. Yes.
Yeah, quick, Sharma.
Yes.
Yes.
Did you hit him? You did not hit him?
No, sir.
Why did you say the other day you hit him?
That day I don't understand, sir. What question you ask me, because I'm very tension about my family problem. That's why. I simply answer.
Why did you not say that I did not understand? Why did you answer without understanding?
Dia bong VO mình chào thụ rất đủ sĩ.
Kadang chỗ stress rio family problem. If you don't admit me, just give me. Berkat sih, tapi saya coba apa ya?
I was under stress the whole night.
Where's the other file which is pending before the CGM? Has it been sent back? Sent back? Okay. 103. Charge plate. Prosecution shall take steps to summon witnesses. Yes. Yes, next.
The accused person step down. Baca baik.
Accused has to sign the charge. Where is the report?
But I need some more time because I could not contact the IO. She did not pick up the call as well.
This order was communicated.
See?
So what do you want? We'll close the evidence of the IO and proceed with the matter.
So give one more chance.
How long you have for trial? You argue the matter. Will impose a cost of rupees 5 lakhs to be paid by the prosecution for making him stand for trial. This is not the way you conduct trial. You don't bring the witness for 1 year, and he or she is none other than the investigating officer. When we pass an order asking you to explain why you could not bring the IO for 1 year before the court, you are again asking. Who are the accused persons who are present? All the accused persons are present?
No, sir, Jerry Meghalaya is absent.
All right. Shimi Paryan,
Present, Simi, Leki, and Trivan Shah,
what is this case?
the party. 6 witnesses.
Will examine. Let them be here. Yes, bring the witness. Give me the chronological dates starting from the FIR.
FIR is filed on 13/2/2007.
FIR on 13.
13/02/2007. Incident was same date, 13/2/2007.
Yes.
Incident also same date.
Okay.
Charge sheeted on 15/3/2007.
15/3/2000.
First came the
Charge sheet. Charge
first
sheet.
came the confessional statement of the accuser, which was recorded on 15/2/2007.
1 minute. Confession statement was recorded during investigation, isn't it?
Yes, yes.
When was the confession statement?
15/2/2007. Yeah.
Yes, under 164.
164. Yeah.
Yes.
Inquest and seizure on 13,
Okay.
and postmortem on 14, same month.
Okay.
Charge frame on 10.
The charge sheet was filed on 15/3/2007.
Yes,
Before whom?
15/3
ADM.
ADM.
No. The compliance of section 207, is there anything?
Okay.
Compliance of 207. Copies was given to you when?
Copies, regarding the 161 was not supplied.
When was the copies given to you?
I have to check, I must see.
Charge sheet was filed on 15/3/2007. Put the 15/3/2007 order. 15/3/2007. When is the charge frame?
10/6/2015.
Ten six. 2000.
15.
Look at the charge. Where's the charge? Yes. Who's appearing in this case? Prosecution.
So PP has some urgency, so he left just now. So appears.
Yes. Yes. Then.
Then the trial start, with 10 witnesses.
Yes. Who? 10 witnesses. Who is the witness who recorded the confession statement?
He died, during trial. However, the person who endorsed appeared, as pre-lieutenant.
Read the confession statement.
I'll read on the part, where he stated that I, Shri Witrasungo, who is the accused person, do hereby confess that I have committed the crime for self-defense. That's the content,
Yes. Yes. Yes.
I'll start,
Hmm.
Start from PW1,
Hmm.
As stated earlier, I'll just come to the argument part, although we have already read the portion of PW1, My argument is that, PW1, where she stated that on hearing the noise, on hearing the accused.
You heard that.
Yes, my argument is that she never stated she saw the accused in the compound, nor she saw him running away, because the time period,
You heard that.
Yes, And I'm coming to the, it will do his the complainant, his secretary, during that relevant time, stated he filed the FIR based on the information received from the villager, I'll go, what PW5, is the Caesar witness, of the Dow, PW5 and PW8 is the Caesar of the Dow, PW5 and PW8. Also, PW8 also a person where extrajudicial was confessional made by the accused to the PW8, I'll come first the Caesar, for PW5 and PW8, as per the evidence of PW8, I'll just come first the Caesar part, She stated that the Dow was seized on being left by the accused, PW8 stated that, However, from the evidence of PW5, he was silent. PW8,
One. Yes, please.
Yes, I'll just go for the Caesar part, not the extrajudicial part, you know. First, the Caesar part.
Read the state.
Yes, sir. The PW8. I was the representative of the National Latmore. I can't remember the date, month, of the year of the incident. On the date of the incident, at around 11 a.m. while I was at home.
9 a.m.
Yes, sir.
9 a.m.
9 a.m. while I was at home, the accused person Vitala Sumo came and confessed before me that he had committed murder on the victim Sri Lajai Kendai. The accused also told me the PO is at that memorial itself near the house of the deceased victim. Therefore, I, along with the secretary, who is PW5, who is the PW2, headman and some other villager followed the accused who went to Satsma police or post to inform about the incident. When we reached the OP, the accused confessed before the police about the commission of the crime, and thereafter the police came along with the accused to the PO. I also saw the dead body of the deceased with a cut injury behind his neck. Thereafter, the accused left the police for the recovery of a dhow, for Khasi dhow at the distance about half kilometer from the PO. I also accompanied the police and the accused person for recovery of the Khasi dhow. The Khasi dhow was taken out by the accused person from the bushes and handed over to the police. Exhibit 2 Caesar list. And also Exhibit 2 by 2 is his signature. I will not be able to identify the Caesar material now as the incident took place long time ago. I know accused person present the dock today as he is my co-villager. In the cross-examination, the seized Khasida is not shown to me before the court today. When the accused came to my house to confess about the crime, there were other 4 persons along with me at the time, but I remember only Per Kendijk as one of the persons who was present at that time. I did not see any injury mark on the person of the accused at the time when he came to my house. I have no knowledge if the deceased was having any enmity with the accused. I know that the deceased victim was in a habit of drinking alcohol, but I do not know if he was a troublemaker in the village. When the accused left the police for recovery of the Khasida, perhaps Susni was also present. I cannot remember the description of the seized Khasida as the incident took place long time back. The police explained to me the content of Exhibit 2 and I was shown the seized material at the spot before I put my signature. And PW5 also is the Caesar, I'll just read his evidence. On the day of the incident, I was passing by through Latnumar village. I saw the dead body of Laja Kandak lying on the roadside. When the police arrived, I accompanied the police to seize the weapon for committing the crime. I saw the police seize the weapon, which is a Casidao. Exhibit 2 is the season list. I'm also on so Exhibit 2 by 1 is his signature. I'll not be able to identify the seized material now as the incident took place a long time ago. Exhibit 2, Exhibit 2 was not yet over to me before putting my signature. The Casita was seized from the place located about 100 meters from where the dead body was lying. I remember that there is another witness to the Exhibit 2, but I do not remember its name. Now, PW8 and PW5 both are seizure of the said down. Now, if we go to statement of PW8, it stated it was seized on being left by the accused. However, in statement of PW5, it was silent about that. Moreover, I'll be relying on Section 27 of the Evidence Act discovery statement. There's no discovery statement in this case. I've placed my citation also before the court, regarding Section 27, Babu Sahiba, para 66,
Okay, 66. Mhm.
para 66,
Yes.
how much information received
Yes,
from the
yes.
accused may be proved. That's
Yes.
and for this extrajudicial confession, now the PWH stated that the accused came to his house on the set day of the incident and confessed before him. And there were also 4 persons. Out of those 4, he remember 1 person, Per Pindak. And he stated right after the accused came to him, he went along with secretary, headman, and some other villager to the Satsma post along with the accused to report the matter. If we go through the statement of the secretary who filed this FIR, he was silent about that, that the accused had confessed before PW8 before filing the FIR. He said that he don't know what's the reason. What's the reason that there was a fight between them. Moreover, this PW5, PW8, stated that there was
This person who was present when the confession statement was made,
yes,
he's been examined as a witness?
this PW8, there is yes or no?
No, he said that 4 persons were present when the
No,
confession.
only one person was examined.
Who?
This PW8. PW8 said there was other 4 also in his house when the accused came. However, only him was examined. The other 4 was not examined before this honorable court. Moreover, the secretary was silent, about this, where the PW8 stated that on reaching the OP, the accused also confessed before the police of commission the crime before they filed FIR. He was silent about that also. In the police station also, he said that he confessed before him also he confessed. He was silent about that, the person who filed the FIR. Moreover, even his statement made that the seizure was on being dead by the accused also, it's different from the other PW5, who is also the seizure in this instant case. So, his statement cannot be relied because it did not corroborate what other statement, because he made statement that there's confession before him. However, other witness was not examined to prove that the accused really came. And also the accused made confession before the police, while the person who filed FIR was silent because he also present there before filing FIR. And one more, that the accused led to the discovery, that also from other witness is not corroborated. And moreover, he didn't state the exact word used by the accused to confess, what was the exact word used. And now coming to the 164 of the accused, if we go to the content of the 164, which was recorded by late J.D. Sungo, however, Pitbull 10, who endorsed the 164 to record the 164 statement, came before this honorable court. If we look onto the content, he stated it was recorded that I, Shri Vettara Sumo, who is accused person, do hereby confess that I have committed the crime for self-defense. There's nothing shows here, what is the crime and what did he confess in the content of 164. Even if we read it as it is, he stated one person he implicated himself, and the one side he justification because he said it's a self-defense. However, it's not clear whether it's linked to this incident or not, because there's not such confess was made by the accused. Specifically, what specific words used by the accused was not there, in this 164. So this is my argument on my part.
Yes.
So the evidence of PW8 with the deceased made an extrajudicial confession is corroborated with the confession statement of the accused. And on examination of the other witnesses, whether the deceased had made confession or not, it's not fatal to the case of the prosecution, Your Honor, because one of the witnesses in the presence of those who had been examined, and which is corroborated by the 164 of the accused person, and even the evidence of the PW1, Your Honor, she said that she confirmed in her cross also that she heard it was the voice of the accused person. And the other witnesses is the PW2 is the one who lodged the FIR, and the other witness is the inquest witness, and PW5 is just a stage witness. And PW6, the inquest witness, had seen the injury on the body of the deceased person. That's all. That's all.
You are relying on some authorities.
I've placed all my
What are those authorities?
this Babu is for section 27, you know, and extrajudicial also this Sahabidevan, and one more, you know, this 2013 CRI. This is Devraj Koyal. That's for 164 statement. You know.
You're referring to Uttar. Yes, and then this one is for what?
Yes, sir. One is for leading to discovery statement, that is section 27. The other is for extrajudicial confession. Yeah. This Sahadevan. I've typed the relevant paragraph. So.
Where is statement? 161 statement. His name is what? Vithal or less? What is there in the FIR?
His name is Vitalasyan.
In the FIR?
It's Lasyan. Less Sumo.
Who is less Sumo and Vithal Sumo?
Yes, you know?
Who is less Sumo and Vithal Sumo?
It's never explained by the prosecutor. But my case was arrested. Charge sheet was filed with Telasumo, as with Telasumo.
IO was not examined.
No, died now.
At the level council. the facts which has given rise to the instant criminal proceeding. Is recorded chronologically. Inasmuch as it has serious bearing in the instant case. Stop. The FIR was filed on 13/2/2007 by the General Secretary of Latmankor village alleging that Lajak India his name is Lajak India Ring Lintin.
Special records Lajak and I.
Call this one was murdered by Lis Ngo of Latmankor village on 13/2/2007 at around 8 a.m. on the roadside. The translation of the FIR is correct now. The FIR was received by Saitsama outpost by GD number 188 dated 14/2/2007 and it was forwarded to Jawai police station. Stop. Jawai police station received the FIR by GD number 321 dated 14/2/2007 at around 9 p.m. and it was registered as Joy PS case number 23/207 under section 302 IPC. The case was endorsed to SI D Chongtru for investigation. During the course of investigation, the accused, what's the name of the accused? Vithilas Songo was arrested. His confession statement was recorded before a magistrate under section 164 of CRPC. The IO held inquest over the body of the deceased. Thereafter, the body was sent for post-mortem examination. The IO, after recording the statement of the witnesses under section 161, concluded the investigation. Okay. Concluded the investigation. Give me the order sheet. In a charge sheet, being CS number, concluded the investigation in a charge sheet number 15/07 dated 15/3/07 under section 302 IPC against the accused witness Suma. The charge sheet was placed before the learned ADM judicial on 21/3/2007. Prior to the separation of judiciary from the executive. After filing of the charge sheet, the matter was pending for appearance of the accused and copies for 6 years. Finally, after separation of the judiciary from the executive, the case was transferred to this court. On 29/7/2013. This court was pleased to remit the case, to the committal court for taking cognizance and committal of the case. For taking cognizance of the offense and committal of the case. Full stop. Here again, comma. The matter was pending for almost a year before the committal court. Comma. It was only on 02/05/14 the case was committed to this court for trial as the offence charge is exclusively triable by session court. It is pertinent to mention that the case was committed after compliance with section 207 of CRPC. The prosecution during the course of trial has examined with evidence. Was committed to this court for trial as the offence charged exclusive trial by the session court. It is mentioned full stop and then full stop. Charge was framed against the accused on 10/6/2015. Full stop. The order dated 10/6/2015 read as hereunder. Quote, prosecution present, accused person Witness Sungo present, with legal aid counsel. Srimati S.L. Pillai. This court hereby frame charge against the accused under section 302 IPC. I have explained the content of the charge frame against the accused. The accused person who pleads guilty comma, since the section charge is under section 302, I hereby direct the accused person to stand trial on the said charge. Upon perusal of the charge form, may continue. That upon perusal of the charge form, this court finds there is no whisper with regard to the accused pleading guilty. Full stop. It can be safely assumed that the plea of guilt by the accused was not accepted by the court. And he was made to stand for trial. On a charge under section 302 IPC. To stop. During the course of trial, the prosecution examined ten PWs and exhibited 5 documents. The accused was examined under section 313. After the conclusion of the prosecution evidence, further, he was also given an opportunity to bring defense witnesses. The accused declined, and the matter proceeded for final argument. This court deems not necessary to reproduce the argument advanced by the rival counsels. However, the contention raised by the rival counsel shall be taken into consideration while evaluating the evidence. That from the argument advanced by the contesting parties, following points emerges for determination. Number 1, whether the accused went to the house whether the accused went in the compound Like whether the accused went to the no, compound to the house of PW1. No, whether the accused entered in the compound of PW1 on 13/2/2007 at around 8 a.m. and struck his brother-in-law Kandai. What is his name? Najai Kandai with a dao and caused his death. Stop. Next para. Analysis and finding. Stop. The prosecution is heavily relying on the testimony of PW1 and PW8.
PW4.
PW1, PW4, and PW8. Stop. PW1, PW4, PW6, PW8, and PW10. Stop. The investigating officer in the instant case would not be examined as he died during the course of trial. Stop. From the evidence of PW1, it emerges that on the day of the incident, she was at home, engaged in her household chores, she saw the deceased passing by her house, as she saw the deceased sitting in the compound of her house, PW1 heard that PW1 heard the accused saying that he's tired of the PW1 heard the accused saying that the deceased. PW1 heard the accused saying that he is tired of the deceased, calling the accused over and again. She heard a noise when she went out of her house. She saw the deceased lying dead with cut injury on his neck. In a cross-examination, she testified that she heard the accused. However, she's not a witness to the, she's not a direct witness to the incident. Full stop. The court has perused the statement of the PW1 recorded under section 161 of CRPC during investigation. With all reservation that the statement of a witness recorded during investigation is not a piece of evidence or cannot be used during the course of trial, save and except for the purpose of contradiction. Full stop. This court, out of curiosity, had put a question on the defense. If the defense has taken into consideration the statement of PW1 under section 161 while cross-examining PW1, the response which the court got from the defense is shocking. The defense stated that the statement was never supplied to the accused under section 207 of CRPC. Stop. The essence of a fair trial demands that the prosecution should not conceal any incriminating materials. The prosecution should not conceal, deprive the accused of any incriminating materials which would be used against the accused during the course of trial. Full stop. At the stage of the final arguments, these issues of non-supply of the documents may appear to be insignificant. However, it taints the fair trial. The defense has failed to contest that non-supply of the copies, non-supply of the statement of PW1 has caused any prejudice. Nevertheless, the it affects the essence of a fair trial. Full stop. This court has laid emphasis on the statement of the PW1 recorded during investigation because the evidence of the PW1 before this court is altogether a new case. The prosecution case during investigation, the evidence, the statement of the PW1 during investigation nowhere inculpates the accused rather the accused appears to be a witness. During trial, PW1 turns out to be a very vital, direct witness to the prosecution case. The defense had an opportunity to impeach the evidence of PW1. However, in absence of the statement under section 161, however, non-supply of the statement under section 161 had deprived the accused to impeach the evidence of PW1. In other words, the accused was deprived to cross-examine the witness PW1. Only on this ground, the evidence of PW1 cannot be acted upon. As the evidence was led by the prosecution, in defiance of the principle of natural justice. Stop. Even on merit of the evidence of PW1, she nowhere stated that the accused had committed the crime. There is a vast distinction between hearing a person and witnessing a person committing an act. The two words cannot be read synonymously. Any endeavor made to do so would lead to travesty of justice. Stop. For the reasons discussed above, the testimony of PW1 cannot be taken into consideration. Reliance placed by the prosecution on the testimony of the Caesar witness PW4. Who are the PW4?
PW5 is a Caesar
PW5
and 8 Caesar.
PW5 and PW8. Is not admissible under law. There is no quarrel with the proposition of law that statement made by an accused before the police officer is admissible under section 27 of the Evidence Act only to the extent of recovery made. Any confession made before the police is not admissible Section 27 of the Evidence Act cannot be stretched to make a confession before police admissible. Stop. When any recovery is made on being led by the police, on being led by the accused, it is sine qua non that the accused should be in the custody of the police. Discovery statement should be recorded. In presence of the independent witnesses. Thereafter, the police should proceed for the recovery and if recovery is made, seizure should be effected. These are not mere procedures. It is a statutory safeguard to protect the accused from being falsely implicated or being coerced by the investigating agency. How recovery is to be made? On being led by the police. On being led by the accused. Has been vividly dealt with by the Honorable Supreme Court, and the Defense Counsel has placed reliance on the same. This is Subramanya versus State of Karnataka, 2023 11 SEC 255. Para 76 reproduced. For easy reference, relevant paragraph, para 76 is reproduced. That on scrutiny of the evidence of the seizure witness PW4 and PW8 on the touchstone of the law discussed above, the recovery and the seizure made in the instant case was not in accordance with law, and the right of the accused, the statutory right of the accused, has been compromised. As such, it is no recovery in the eye of law. Next, the prosecution case is only confessional statement. The defense has relied on a decision of the Honorable Supreme Court reported in 2011 to SCC 490. Ravindra Kumar Pal versus Republic of India. To impress upon this court that the confession statement was not recorded. The confession statement is exhibit. Exhibit. The confession statement exhibit was not recorded in accordance with law.
Exhibit 5.
Right. The relevant paragraph is reproduced. Is para 18. Gustav. Without going into the statutory safeguard, without going into the merit of the confession statement and the manner in which it was recorded, this court finds the confession statement on the face of the record is cryptic and cannot be deciphered. The accused stated quote, I, Shri Vitalis Sungo, do hereby confess that I had committed the crime for self-defense. What was the crime? Question mark. Court, while appreciating the evidence, cannot insert its own ideas and beliefs and perception. And add anything which is not there. Confession is an admission of a crime. Any act which is an offense, any act which is otherwise an offense is no offense if it is done in self-defense. If we take the so-called confession statement of the accused on the face value, it is no confession statement in the eye of law, comma. Rather, it is An exculpating statement exonerating the accused of his act. Full stop. Surprisingly, it is the prosecution which is relying on the statement of the accused that he acted upon self-defense. The prosecution case fails only on this ground. Full stop. The other argument of the prosecution is on the extrajudicial confession made by the accused before PW8. The defense has rightly contended by placing reliance, where is that? By placing reliance, where is that? Where is your where you have placed that? Rightly contended by placing reliance on, where is that? What is the citation?
Sahadevan.
Huh?
Sahadevan.
By placing reliance on Sahadevan, Sahadevan, Sahadevan versus State of Tamil Nadu, 2012 6 SCC 403. Relevant paragraph are paragraph 14 and 15. Uh, 14, 15. Full stop. It is settled law that the extrajudicial statement, extrajudicial confession is a very weak piece of evidence. It cannot be acted upon unless there is strong corroboration. The evidence of PW8 reveals that when the accused had made confession before him, there were 4 persons who heard the confession. None appeared before this court to confirm or to establish the extrajudicial confession. The testimony of the informant is PW2. The testimony of the informant PW2 is silent. about the confession made by the accused. None of the witnesses has whispered about the accused confessing before PW8. It will be highly unsafe to rely on an extrajudicial confession which does not have any support of other evidence. Full stop. A crime being committed and a crime being established during trial through a lawful evidence sorry, a crime being established, no, sorry, a crime being established during trial through a lawful evidence is required. Is the requirement of a criminal trial. Full stop. A criminal case has to be decided based on lawful evidence produced during the course of trial. Any deviation from the standard of beyond reasonable doubt would amount to the aberration of rule of law. So, that this court has not touched upon the medical evidence and the autopsy report, inasmuch as this was not a case where this court was deciding only if the death of the deceased was homicide. It was a trial where the accused was standing facing charge of a homicide. The prosecution has to establish not only the crime has been committed, but the accused has committed the crime through a lawful evidence. Unfortunately, the prosecution has miserably failed to establish the charge for the reasons discussed above. This court finds the conclusion is inescapable accused acquitted of the charge under section 302 IPC and set at liberty, the bail bond of the accused shall also stand discharged. Case stands disposed of on merit. Next. What is that other? Yes. Yes, what is this case? How many witnesses here? 9.
9 witnesses.
Here also statement recorded 164
Yes, sir.
of the accused.
Of the victim, not of the accused, of the victim and the witnesses.
Let's read the evidence of the victim. Yes, who is appearing for the prosecution? Huh? Sorry. Victim has appeared. This is 307.
Yes, sir. 307, 341, 326, and 307.
Victim is alive, isn't it?
Yes, sir.
All right.
The victim is still staying with the accused till date.
Accused.
Yes, sir.
What time do we stay separately?
Huh? Let them live happily. Then what is it? Who is victim has come as PW?
PW1.
1.
Yes.
Yes. Let's see what the victim says.
Yes.
I am the complainant and also the victim in this case. I cannot remember the date, month, and year of the incident, but the incident took place 6 years back. On the day of the incident, I was all alone washing clothes at a place called Marban Mohaniang Kleterchi. There were also some kids around. Suddenly, my ex-husband, Sri Rampawa, came from behind and struck me with a dao thrice on my head. When I was hit on the first time, I do not know who was the person behind me. But when I was hit for the second time, I turned back and saw it was the accused Rampawa who had assaulted me. I was bleeding profusely from my head, and though I made an attempt to run away, but I could not, and I suddenly fainted and became unconscious. When I regained back my senses in the evening time, I saw myself in the hospital along with my family members. I was admitted in Yalong Civil Hospital for 2 days and 2 nights. After I was discharged, the doctor advised me to visit Kleterchi PHC for dressing of my wound. Later, I went to lodge a complaint against the accused. Exhibit 1 is the FIR.
Okay.
Then,
Okay. What is there in the FIR? Let's read. With the FIR.
FIR kat kum katay subject balik kadewan nga kadurka rambai khon jong gariti rambai mo kanyang Kleterchi. Mawan ban bo ya kanek jing jor khmat kaburom jong fi persyai ram hawa ukhon jong kabret hawa so and so Kleterchi ubade ulok jong tang klem yeshong shu la news nem. Baha ka arpusan rik brai bakandai arjar katsana ka porlai beje men janme te uram hawa uluwan kansana ka jaka sa jain shalom kabadon hamarban mo kanyang ula saya ka wait bano pom ding but ula pom yang hado lai sen kle lem don daw ay engro bat nga la patak ban het yam but hamar hanta.
Okay. Let's come to the statement under 164. Exhibit.
On the 25th, 12th.
What is this? How many pages? Okay. Exhibit 3. Yes, let's read.
On the 25/10/2015, on the market day in July, I went to wash clothes in a place called Marban in Kleterchi. When I had finished to wash Around half of the clothes at around 2:30 p.m. My husband Sri Ram Pawar came from behind and hit me on my head. When he hit me for the first time, I thought it was
Okay,
a
okay,
stick.
okay, one second.
And I turned-
Who recorded this PW?
This is PW1
Who recorded her statement?
magistrate.
She came before this court as a witness.
Yes.
PW
Yes.
5.
PW7.
Okay. See, what is the cross examination of PW1?
PW8.
PW.
8. What is the cross examination of PW1? What has come out in the cross examination?
Cross examination. I do not know how to read and write, but I can put my signature. I'm having a very weak eyesight, so I will not be able to see what is written in the paper. It is a fact that I have not written Exhibit 1, and I also do not know what is its content are. I cannot remember if the statement made before the magistrate.
Okay,
and
okay, okay,
one-
okay, 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 okay. Okay. Take the judgment. How many years he's been in jail?
Almost 9 to 10 months.
Okay. Okay. Anything you have?
Yes, Your Honor, I've already placed my argument earlier.
No, but what is
And
your
the-
thing? Just refresh me. What is it?
Your Honor, regarding this case, I have put my contentions on the
No,
credibility of
we
the
will not go on the merit of the on the case laws.
Yes.
We will go on the facts of the case. Tell me on the factual aspect of the matter.
This case,
Yes.
the accused person in his 313 has admitted that on the day.
No. 313 has to be read with the evidence.
Exactly.
Yes.
So I'll start first
Yes,
with
yes.
the 313.
Yes.
In 313 has stated that on the day when he went to Morban, this place of a PO, he met his wife with PW2, who is the ex-husband of the victim.
That's fine.
Yes, Your Honor.
That's one second. Before we look into his statement under 313,
Yes.
what is the evidentiary value of a statement under 313?
And it has no
Is
evidence.
this is a explanation given under 313 is an evidence?
No, no.
That,
Yes.
if he wanted to say so, what he stated in 313,
Yes.
he could have converted his statement under 313 into evidence.
Yes.
What stopped him from coming to the court as a witness under section 315? And what he wanted to say, he could have said before this court,
Yes.
and what he said could also have been cross-examined by the prosecution. Then it becomes an evidence, and we would have acted upon it.
Because his statement under 313 is corroborated with other witnesses.
No, it is not an evidence.
Yes.
We don't. 313 is only for the purpose of understanding the prosecution evidence.
Yes.
For understanding the prosecution evidence, for explaining the prosecution evidence.
Yes.
But 313 in itself is not an evidence. So the explanation given by the accused, read with the evidence of the prosecution together,
Yes.
then we can understand the evidence of the prosecution.
Yes.
So by that understanding may also give us an understanding that no, what the witness has said is not correct. What the accused said, it makes sense. There is a logic there. There is a sense there. Only for that purpose. But it is not a piece of evidence. If the accused is taking a contrary stand to the evidence of the witnesses, prosecution witnesses, then that is why after 313 you have to lead DWs.
Yes.
So whatever you have stated under 313, you prove it.
Yes.
Not that the accused is absolved from disproving things. And how do you disprove it? By leading evidence. Not under 313 can be understood only to that extent that we understand the prosecution evidence. But 313 is not an evidence.
Yes.
Yes. What else? What is the credibility? Why should we not? Why should we not believe this lady?
Your Honor, because from her statement, it's very contradicting.
What is
Your Honor,
contradicting?
she has mentioned in her statement before the court, before the magistrate, with regard to being unconscious after
Correct.
the accused hit her.
Hmm.
In one statement, she stated that she fainted there and then, and she regained her consciousness in the hospital. In one statement, she stated that after being unconscious, she regained her consciousness at home. That is one thing. And the other aspect is that in her statement before the magistrate, she stated about the 5 boys that who had helped her. These 5 boys were never cited as a prosecution witness. However, before this honorable court, she has mentioned 2 boys. So that's a huge contradiction. And the fact that she has stated that the accused person is her ex-husband, that is also false, as per the statement of one of the prosecution witness, where she had admitted in the cross-examination that the accused person was still staying with the victim during that point of time when the incident happened. However, the change in the facts of the case is that when PW2 was examined, Shining Power is the ex-husband, and she was Shani Pawar had an affair with the victim, and the accused person met them, and that is where the confrontation started. And however, this fact was never brought before the honorable court by the prosecution. Therefore, they have pressed this material fact on. And also the fact that the victim herself has admitted in a cross that after the incident, I had forgiven the accused person. And at this point of time, they're still staying together. Before he was arrested, they were still staying together. So these are my, and also Your Honor, the DAO which was used in this case, it has never been produced before this honorable court. And the injuries as well, which was as per the medical report, the doctor who had conducted the medical examination of the victim had never specifically explained the kind of injuries sustained on the victim. Whether it was a laceration wound, abrasion wound, nothing was specifically mentioned. And the fact that the victim was never hospitalized in this case also.
No. She suffered serious injury.
We cannot say whether she suffered serious injury or not. Explanation has never been given by the prosecution as per the evidence.
What is the medical report says?
The medical report says found 3 wounds on the head of the patient. There are 3 wounds on the head of the patient. The first wound was on the frontal area, midline, measure 7 centimeter. The second wound was on the right.
You have a scale.
No, sir.
You have scale, measuring scale.
No, sir. Don't have, sir.
You have scale. Measuring how much? 7 centimeters.
7 centimeter. And the,
Yes, sir.
and the second wound.
It's 7 centimeter. But however, the kind of wound, the doctor had only mentioned wound. What
7
kind of
centimeter wound. What is it?
Yes, sir. Because
No, inches down. This 7 is here.
CM.
Yeah, this is 7.
because looking at the word wound, there are different types of wound. What kind of wound it is? Whether it's, yes,
7 centimeter.
I understand the explanation given by the doctor. However, the kind of injuries sustained by the victim, he has never explained.
No.
Whether he has suffered abrasion, laceration.
Read section 307. Does it say that there should be a serious injury?
No. Intention and.
It says that hurt.
Yes.
Hurt has been defined under section 319. Even a pain is hurt.
Yes.
What is hurt has been defined under section 319. So section 307 talks about this attempt to murder has got 2 parts. One, you make an attempt to murder without causing any injury, any hurt, where the punishment can extend up to 10 years.
Yes.
But while making an attempt to murder, if you cause any hurt, then the punishment can extend up to life imprisonment. And what is hurt has been defined under section 319.
Yes.
Hurt does not mean that there should be some injury.
Yes.
Even a pain is hurt.
Yes.
That's the definition says.
Exactly. But in this case,
here we have an injury which is a 7 centimeter. What
yes,
else you
7 centimeter.
Will it not come within the definition of hurt?
Yes, because this is the case of grievous hurt.
No. what is the, that's why I asked that what is the distinction, between if you cause hurt somebody, it is an hurt or grievous hurt or simple injury or a hurt. But when does the hurt becomes attempt to murder? See, attempt to murder, what is the distinction between causing injury, which is not an attempt to murder, but simply injury, but that injury becomes attempt to murder? What is the distinction? The only distinction is this, that had you succeeded, he would have died.
Yes.
Attempt to murder means you did everything to kill him, but you did not succeed. Had you succeeded, he would have died. Your intention was to kill. Striking on somebody's head 3 times with a knife.
No, the knife was never proven in this case.
She says.
Yes, Your Honor, she may say, but it's not proven as per the on record.
She says, and look at the medical evidence.
Yes.
3 injury on her head. Does it not corroborate with what she said? Struck in the FIR, she says struck 3 times.
Yes.
Before this court, she says 3 times. 164, she says 3 times. Medical report says 3 injuries on the head. What else do you want?
And then there is also a fracture on the outside pulse of the bone.
Yes. Why do we require seizure of the knife? Who is this victim? The victim is injured victim is an eyewitness to the incident. She saw. She's a witness, eyewitness to the incident. She's not an ordinary person. She's not like any other witness. She's an eyewitness to the incident. She's an injured witness. And a person suffering injury on a head, why would she implicate somebody and say that somebody else had hit me? Somebody had caused injury to her, isn't it? Why would she try to shield the real perpetrator and implicate the accused when there is an evidence that she suffered some injury? Unless you can say that there was a dispute, matrimonial dispute, there was a matrimonial dispute. Out of vengeance, she had implicated. Nothing of that sort has come.
You know, on the
It
last
goes
day,
against
I've
you.
argued on that
You say that
aspect.
your argument is that the witness and the victim and the accused are husband and wife. If they're husband and wife, they're staying together. Why would she implicate this man?
You know, as per the facts of the case, what has come out as per the record, during the time when the accused was staying with the victim had an affair with PW2, and this fact was never brought by the prosecution. And it has
That may help you. That may help you on the sentence.
Yes. You know,
we are not concerned about why the crime was committed.
Yes.
That leave it to the sociological department. Social welfare department, they'll do some research. Why crimes are being committed? How is the society degrading?
Yes.
Why people are committing crime? This is not our job. We will be confined to the charge and the evidence. There's a charge sheet file. Charge has been framed under IPC. Whether the evidence has come to show that whether you have committed the crime or not. The circumstances under which you have committed the crime will be relevant factors to be taken into consideration if we find you guilty to punish you. We may show some leniency to punish you because of the circumstances. But circumstances cannot justify. Unless you have circumstances which falls in the category of a self-defense.
Yes.
That you had no option but to save your life. In order to save your life, you had killed somebody. Yes.
Yes, in this case, with regard to section 307 IPC, which has been charged against me, the intention and knowledge is absent in this case, because this is the case where the accused found out the victim was having an affair with one person, Shining Power, and on that particular day.
How do we establish, tell me, how do we establish or how do we negate? When can we say that the intention has been established? Or how can we say that the intention has not been established? What is intention? Intention is a state of mind.
Yes.
How can we say that the intention has been established? Or how can we say that the intention has not been established? in a criminal trial. What is the yardstick?
It should be a pre-planned preparation.
How do we know it's planned?
Yes, exactly.
See, it is impossible to get evidence of intention.
Yes.
Intention is a state of mind. Only inference is drawn from the established evidence that intention was there. Intention can be appreciated only through other evidence, only by drawing inference. Suppose if you take a gun and you shoot in somebody's leg, that shows that you did not have an intention to kill him. Shooting in somebody's leg, that the intention is not to kill him. But if you aim on his head and you miss, there is no hurt, no injury, but had the bullet struck on the head, he would have died. So your intention of shooting at somebody was with an intention to cause his death. So that shooting on which part of the body? From there we gather the intention by drawing inference. So intention will not have any evidence. It has to be gathered or inferred from the other evidence. Striking on somebody's head thrice with a dao. Tell me, what is the intention?
The argument that there's a dao in this case, it does not apply in this case, because the dao was never.
Somebody says that he shot me with a bullet. Neither the gun sees nor the bullet sees, but this man was taken to the hospital with a bullet injury. We'll say no. The gun was never seized. That's why this injury is not a bullet injury.
If the bullet was present, then we can assume.
No, not even if there is an injury with a bullet. Medical evidence is there that there is an injury with a bullet. Non-seizure of the bullet and the gun will not falsify the evidence of a person. We will not demand that we have to produce the gun to establish that he was shot with a bullet. When the lady says that I was being hit with the dao on her head, and there is a medical evidence to establish that she had head injury, why we should not believe me? Show me some evidence, show me something which has come during trial that these facts are unbelievable. Did she get any compensation, this lady? Can we continue after lunch?
Yes, I'll just go through this once.
Continue after lunch. And what happened to this case? Have you filed any report? Oh, that matter will take 5 o'clock. Just 2 million up. Maybe, huh?
We'll try to call her again, sir. We'll try to call her again.
Why don't you go and beg before her? Go beg before her that please come. If she's not cooperating, either we close the PWs. If you want that we should take coercive steps, we will take coercive steps. We can secure her presence. What's so difficult about it? If there is genuine difficulty for her to appear before this court, we'll accommodate her. A person might be sick for a year. How can he come to the court? But that's what exactly I want to know, and I've asked the prosecution to file a detailed report as to why the witness has not come to the court for a period of 1 year. So that this court will know that why the witness has not come to the court in spite of dozens of summons being issued. If she's sick, we have to accommodate her. But if she's evading the trial or she's deliberately not appearing before this court, you can make a prayer that we should take a coercive steps to secure her presence. We'll certainly do it.
Since the last date, sir, I tried calling her many times so that I can file a detailed report, but she didn't pick up the call. So
You have to call up, you have to talk to the SP. This is the order the court has asked.
that's why, sir, just give us one more chance. We'll
No chance, no.
talk with her.
What is this chance we have asked? What chance for what? We had already given you a chance to explain that what is the matter all about. Please explain us. But you have chosen to keep quiet. And now you are asking, in a case which has been delayed for non-appearance of the witnesses, we asked that why the witness is not appearing. Now you are adding salt to the injury by asking further time to explain.
No, just for this one last time, sir, not more than one.
We'll pass the matter there. We might hear the matter. How long you are facing trial?
The trial started in the year 2019.
19. What is the charge against you?
376.